Mr. Katsas, welcome.
Thank you.
I was interested to learn that in 2007 you had testified against the Native Hawaiian Reorganization Act. That was the Department of Justice's position.
Right.
And you based that position that you had a concern about the bill really relying on suspect lines of race and ethnicity, so racially defined. Are not American Indians and Alaska Natives racially defined groups?
So the issue, Native American Indians are different. There is a line of Supreme Court precedent saying that classifications based on tribal statutes are political rather than racial. But there was also a decision of the Supreme Court in a case called Rice versus Cayetano.
I'm familiar with that decision, and in fact, that was a state action case, and the state itself cannot define an election along those kind of lines. So I would limit it to a state action case.
Well, it was a decision in which the Supreme Court specifically rejected the analogy to Indian law in the context of a statute that tried to treat Native Hawaiians like Indians.
I attended that hearing. There were a lot of questions about whether or not the Native Hawaiians have been organized as tribes, which they are not. But are they not? Do you not consider them an indigenous peoples?
They are, to my knowledge, they are an indigenous people.
So why should they not be treated as American Indians and Alaska Natives, who are also deemed indigenous peoples, although they may have governed themselves differently than the monarchy that the Native Hawaiians had?
The issue, as I understand it, is when the United States deals with tribes, it is a government-to-government relationship. It is like when the United States deals with foreign countries. You wouldn't regard our conduct of foreign affairs as raising nationality-based distinctions because we're dealing with a foreign country. So the question is whether a statute that defines preferred status by reference to ancestry, tracing lineage to original indigenous people, is more like a racial classification or more like a government classification.
Well, obviously, I do not agree with you. And as I had attended the Rice hearing and I read that, and I have quite a background myself. And in fact, your testimony was contradicted. Your position was contradicted by eminent scholars, or Neo Catiel, Vietnam, and others. So let's move on.
May I respond just briefly?
Well, let's just say I'm glad that you consider Native Hawaiians to be Native peoples, because a lot of what follows, I think, is very dependent on that kind of classification. Let me move on to, you told Senator Feinstein that you worked on the travel ban executive order when you were in the White House. And you are a very talented lawyer. Did you think that the first version was constitutional in view of the president's comments about wanting to impose a Muslim ban?
The Office of Legal Counsel opined in the ordinary course that the order was lawful, and the Civil Division of the Justice Department and the Solicitor General's Office are defending the constitutionality of those orders in court. That is the government's position.
So let me ask you, though, because you are going to the D.C. Circuit. So in terms of how the president's executive order, in view of his statements that he wanted to impose a Muslim ban, should be viewed, and as you well know, the district court in Hawaii deemed that second executive order to be unconstitutional. So regarding your view on judicial review of an executive order or a statute, should that judicial review confine itself to the words of the executive order or the statute, and not through things such as evidentiary statements such as the president saying he wants to impose a Muslim ban?
That is an issue in the pending cases, and the Solicitor General's office has argued that campaign statements should not generally be considered, and if they are considered, should be considered in light of later developments, like what a president says after taking office and how an executive order operates on its face.
So your view is that statements are also relevant to a determination of what the impact or the intent of an executive order or a statute should be.
The government's view is that such statements are generally irrelevant or minimally probative.
Is that your view?
I don't think, I wouldn't be appropriate for me to express a personal view, and it wouldn't be appropriate for me as a lawyer for a client with a pending case to undercut the arguments that that client is making in court.